Welcome, everyone. For those of you whom I have never met, I'm Elizabeth Kelley, and I'm very grateful that you joined us here tonight for the online book launch of the second edition of my book, Representing People with Mental Disabilities, A Practical Guide for Criminal Defense Lawyers, published by the American Bar Association. We are recording this event on August 10th. And as you may know, today is World Mental Health Awareness Day. Nothing could be more appropriate than to have this event on this particular evening. First of all, we are going to start the program with a welcome from Michelle Benke, who is the president-elect of the American Bar Association. And then we will progress to the centerpiece of this event, that is to say, an interview with two of the authors of chapters in this book, Dr. Elliott Atkins and Dr. Jemour Maddux. Then we'll leave a bit of time for questions and answers, and then we will adjourn. So without further delay, I will bring on a recorded welcome from Michelle Benke. And if you will bear with me, I have to follow the step-by-step instructions I was given in order to bring this video up.
Hello, I'm Michelle Benke, President-elect of the American Bar Association. It's my pleasure to welcome you to this important conversation about mental disabilities in the criminal justice system, brought to you by Elizabeth Kelley, a prolific author with the ABA and valuable leader in the ABA criminal justice section. Elizabeth is a very active ABA member who has contributed so much to our profession and continuing education. The ABA Criminal Justice Section is a leader in developing and advocating for reforms in our criminal justice system, often in collaboration with other ABA groups, including the Commission on Mental and Physical Disability Law, the Coalition on Racial and Ethnic Justice, and the Commission on Domestic and Sexual Violence. The breadth and depth of the ABA's advocacy on important issues of law and justice is what makes our association so valuable and authoritative, relied on by lawyers, judges, and policymakers throughout the country. Elizabeth is a criminal defense lawyer with a nationwide practice focused on representing people with mental disabilities. For more than 20 years, she has dedicated her career to helping vulnerable people in the criminal legal system and to educating others on how resources and skills can be used to defend and advocate for these individuals. Her fifth and newest book from the American Bar Association, titled Representing People with Mental Disabilities, is a practical guide for all criminal defense lawyers. The ABA is proud to produce this book, as well as other resources for lawyers in all areas of practice and practice settings. If you are already a member of the ABA, thank you for your membership. If you're not yet a member, please visit our website at ambar.org to learn more, or ambar.org/membership to join. To start the dialogue about representing people with mental disabilities, I am pleased to introduce Elizabeth Kelley. Elizabeth, we appreciate your involvement with the ABA, which helps us to help lawyers and lead on critical justice system reform issues. Elizabeth?
Thank you, Michelle. And again, thank you to the American Bar Association for all of its support. And we look forward to Michelle Benke's leadership for this wonderful and ever powerful organization. Now, as I said, we're going to move to the heart of the program, that is to say, an interview with Dr. Elliott Atkins and Dr. Jemour Maddux. You can read detailed biographies of these two distinguished doctors, experts, and scholars in my book and in the show notes. But for purposes of this particular event, I'll introduce briefly Dr. Atkins first. Dr. Elliott Atkins is a longtime legendary practitioner. He is a forensic psychologist who has testified in federal as well as state courts throughout the country on behalf of both the defense as well as prosecution. And Dr. Atkins wrote the chapter in my book titled Working with Experts. We are also going to hear from Dr. Jemour Maddux. Dr. Maddux authored the chapter on forensic testing. Dr. Maddux has been active in leadership roles in a variety of professional organizations, and he currently serves on the faculty of William Patterson University in New Jersey. Thank you, both of you, for joining us tonight, and more importantly, thank you for the magnificent chapters you wrote in the book. Let's start, first of all, with you, Dr. Atkins. Frequently, families of individuals who have mental disabilities say to me, our loved one for years has been treated by a psychiatrist or by a psychologist. Why do we need to go to the expense and the trouble of having an independent forensic evaluation? What should the response be?
Treating clinicians know their clients, their patients very well. And they've come to understand them, and they've developed a relationship that is both supportive and therapeutic, and that hopefully positive relationship should make that treater, make that particular mental health person a really good expert witness. But that's not the case. I mean, it could be, but it's typically not the case. There are several reasons why the treating clinician should not be placed in the role as expert or as an expert mental health report writer, testifier, evaluator, consultant. The treatment relationship that the clinical psychologist has with the patient involves a mutual trust and respect, and a willingness on the part of the therapist to accept at face value what the client is experiencing, how they present their history, who they are. And although the clinician may over the years confront their patient about inconsistencies, it's not the clinician's job to be confrontative in general or to be critical. But when it comes down to a criminal matter, what the court needs, what the criminal defense attorney needs, is somebody who is objective, who does not have that treatment relationship with the client, who is able to look at the client in a totally objective way and not have to worry about whether his opinions are going to damage the treatment relationship. Most of the time, the issue as to whether or not a forensic psychologist should be brought into the picture is raised by the patient's criminal defense lawyer. The criminal defense lawyer will say to the patient, after they've gotten themselves involved in some kind of criminal matter, we need to hire a forensic psychologist. And the patient, as you said, Elizabeth, and the patient's family will say, well, we've got the therapist who knows the patient really well. Why can't we use them? I just gave you what I believe are the primary reasons, but what the attorney should say to the family or to this treating clinician is we need somebody to look at this with fresh eyes and objectivity, somebody who is not going to base their opinions on the effect that their opinions might have on the client. It's to testify in court as an independent, objective evaluator.
Now, Dr. Atkins, both you as well as Dr. Maddux are forensic psychologists. Do forensic psychologists undergo any type of special training that, for instance, enables them to work with lawyers or write reports or even testify?
I did not. I know that Jemour has undergone that training. I was originally practicing as a clinical psychologist, actually a school psychologist and clinical psychologist. And when my clients got into trouble, I would sometimes be brought in to testify about my clients. I wasn't necessarily an expert witness. I just got done explaining why the treating clinician shouldn't be doing that, but I was.
Sure.
And there weren't as many forensic psychologists around in those days. And the experiences that I would have testifying in court for my clients wound up being something that the lawyers found valuable, that I found to be fascinating, enjoyable for me to be able to interface with the legal system, with the criminal justice system. And attorneys started calling me not to talk about my patients, but to talk about their clients. And that transition took place in the early 1980s after I had been practicing as a clinical psychologist for about 7 or 8, maybe 9 years. And the experience that I had testifying in those early criminal cases, that experience began my road to an education as to what it takes to be a forensic psychologist. When I was in training, there was not a specialty in forensic psychology where I went to school at Temple University. There may have been some somewhere in the country, but I don't think there were too many. And as a result, I had to wind up testifying in court without being able to say that I was trained or taught how to be a forensic psychologist. Somehow I got through that hurdle, and I've been able to keep doing this for the last 45 years.
What a story. Now, I'm going to ask the inverse of that. In other words, when a criminal defense lawyer is seeking a forensic mental health expert, be it a forensic psychologist or psychiatrist, what are some of the qualities they should look for?
You're asking me, right?
Yes.
Okay. I believe that the reason that the attorneys that originally saw me testify in court for my patients would call me to be an expert was because I was able to communicate effectively with either the judge or the jury or both. That I had a way of humanizing my patient in those days and eventually the lawyer's client as the years went on. That I had a way of being responsive to the questions that were being asked, and that I was not terribly arrogant or self-absorbed, or as unfortunately some forensic experts I've met have been. I was not trying to present myself as much more intelligent or capable or understanding than the average juror was, or certainly than the judge was. I try to speak in a way that would allow people to understand the technical issues that were involved. And I was able to do it in a way that wasn't condescending and wasn't arrogant. I believe that's part of it.
All right, thank you. And Dr. Maddux, I have a few questions for you. And I'm going to start with one that may seem rather irreverent, but please explain to us the significance of your email. For those of you in the cyber audience, you should know that Dr. Maddux's email address is as follows: jm@rule702.com. What's the significance of this, Dr. Maddux?
That's a fun question to answer, and congratulations on the publication of this excellent book.
Thank
and it was
you.
an honor to be a part of it. So, all right, check it out. Rule 702 of the Federal Rules of Evidence, it governs the admissibility of expert testimony. So you can't just go into court and put everything before the court to hear willy-nilly, so to speak. There are rules that control what the court is allowed to hear. And many of these rules are found in what's called the 700 series. It's this group of federal rules that govern what's allowed in and what isn't. Rule 702 really appeals to me because it's the rule that controls expert testimony being allowed to come before the court. Essentially, it says something to the effect that one must have specialized knowledge that will help the jury understand the evidence in a way that makes it more or less factual. It says something to the effect that our testimony has to be based on sufficient facts or data. We can't just come in and say, did you see the letters behind my name? Listen to me. We can't do that. Our opinions have to be based on facts and data. Also, our methods and principles have to be reliable or valid. And there are some other things that control whether or not our testimony is allowed to be heard. So essentially, without Rule 702, I would be out of a job. There would be nothing that would give the court permission to hear from people like me in a way that could be significant and relevant to the case. Rule 702 shapes that. So I figured that it deserves to be my email. And it's something that lawyers, most of my clients are indeed lawyers, immediately recognize. And I think it kind of gives them the sense that, okay, this guy kind of knows the intersection of psychology and law.
Indeed, indeed. Great email address, great response. And for those in the cyber audience who are not lawyers, you should know that although Dr. Maddux addressed the federal rules of evidence, the 50 states throughout the country have some version of the federal rules as well. Dr. Maddux, you of course wrote the book on testing in the book. And could you explain for everyone what forensic mental health testing is and what the significance of it is in a forensic mental health evaluation?
This is something I can totally get wonky about, but I'm gonna try.
Don't get too wonky.
I'm gonna try to keep it, colloquial and to boil it down to brass tacks. It's just one of many methods that we use to test hypotheses about what is going on in this case and to form hypotheses about what's going on in the case. It's just one of many methods. Now, this particular method isn't so different from tests that you may have taken for, like, let's say college entrance, like the SAT, or something to that effect. In other words, it's some document with a bunch of questions, and the questions usually, you can tell by looking at them, would be helpful in determining a particular fact. For instance, a test about depression might ask something about, hey, do you cry a lot? So it'll have questions on there having to do with sadness and so forth. In other words, it'll have what we call face validity. You'd be able to look at it on its face and see, okay, this is probably a test about depression. So a test developer would write down a whole bunch of questions that have something to do with depression. Many of them would be face valid, right? And then that person who's designing the test would give this draft instrument, if you will, to a group of a lot of people to kind of see how they answer it. And in this group of a lot of people, some of them are going to be depressed and some aren't. And if this test is any good that this developer put together, it should do a pretty decent job at being able to determine accurately the depressed people from the non-depressed people. And also looking at how those two different groups responded to the test, it'll give the developer, who's going to do a bunch of stats and numbers, the ability to see, all right, what does a 6 mean on this particular scale as opposed to a 10? Is that like a dramatic difference or not a dramatic difference? Right? So this group that's getting the test to kind of help the developer figure out if it's working right and what it means, that's called the standardization group or the comparison group. So when I'm using this test in order to explore whether or not someone has trauma and how that might be considered in their criminal sentencing hearing, right? When I'm using that test, I'm really comparing my examinee's answers to someone in that comparison group, right? And if they score very similar to the folks who are really, like, let's say, traumatized in that group, then it gives me a good understanding about this particular person's level of trauma as just one source of data that might inform the question I'm being asked to answer by the court. So important things to know, just to recap. You're being compared to someone else when you do a test typically, and it's just one source of data, and we can't cherry pick our data. We have to bring it all together with the interview data, the information that you as mom might be providing to me during a collateral interview, the information I'm seeing during my assessment of someone. All of that gets put together in order to form an opinion about what's going on in the case.
Now, periodically, when I mention to a client that a component of their forensic mental health evaluation is testing, the client asks me, can I prepare for the test? What is the appropriate response?
Yes, you can prepare, but probably not in the way that the client is hoping.
Okay.
The client might be hoping that the preparation will involve like true or false to question 23, but that's not the type of preparation that's advisable to provide, even if able to provide it. The ways that a client could be prepared is by being given an understanding of, why am I taking this test? And what aspects of my mental health is the evaluator assessing? Preparation should involve being equipped with an understanding of your rights as an examinee, and when you should refuse to answer a question that's being asked of you, given constitutional protections. You should be told that, listen, testing can be long, and you might want to bring some snacks. You definitely want to bring your glasses, and you should bring things to drink, and you should know you can request breaks if need be. So this is the type of preparation that is really helpful. Like Elliott said too, I think it's important for the person to know via prep that this is not your therapist. So you don't want to walk in and treat this relationship as if you're sitting before a helping professional. As forensic psychologists, we're not there to help you. We're there to help the court. And our allegiance is to the fact finder, not to our examinee, and not even to the person who retained us. So it's important that the lawyer's client, our examinee, knows that fact, so that they don't come in and spill a lot of information that is not only irrelevant to the examination, but could potentially bias the examiner in a way that isn't helpful for the assessment and the overall case.
And I always tell my clients to be as open and as truthful as possible, and to give the testing as well as every other aspect of the evaluation 101%. Let's go back to Dr. Atkins with another question. What, in your experience, are some of the requirements of a thorough forensic mental health evaluation?
The idea of triangulation comes to mind. The idea that the forensic mental health evaluator draws their knowledge about the client from multiple sources of information, and that the goal is to find some way of seeing how those pieces fit together. I call it triangulation because the psychological testing that Jemour just described is a component. The actual face-to-face interview with the client is a component. Reviewing the records is a component. Talking to the attorney and gathering information from the criminal defense attorney is a component. And collateral interviews is usually a very important component. Speaking to the family or the spouses or the children or friends or the employer of the client will be a source of information that can be utilized to triangulate so that we look at what does the testing, my personal interview and the collateral interviews, what do they have in common? Are they describing the same person? If there is a difference in what they're describing or who they're describing, I need to explore that. If the pieces start to fit together and form a unified, cohesive sense of who this person is, what their mental health history is, why they may or may not have wound up going down this criminal path, if in fact they are guilty, that kind of consensus gives me confidence that my testimony will have a sufficient foundation to convince the trier of fact, whether it be jury or judge, that what I'm speaking about is based upon more than just any one of those individual components that I just described.
Now, Dr. Atkins, you recommend or you mentioned review of documents. What sort of documents are you referring to?
Well, I could drive criminal defense lawyers crazy because I look for things that some attorneys may feel are either irrelevant or unnecessary or overkill. But, obviously I need school records, I need medical records, mental health records, criminal records, the rap sheet or whatever legal history the person might have. But I also try to get a hold of employment records. I try to see how this person is being assessed or evaluated by or understood by the people they work for, the people they work with. I try to find records of their specific activities in the community, whether it's a politician that I'm evaluating or if it's an attorney I'm evaluating. I want to know as much as I can about the way they have been perceived and the way they have interacted with their particular communities or with their particular professions. And when I ask defense attorneys to get me those records, they usually do, and they usually cooperate, but some of them feel like I might be overdoing it.
Well, and I always tell families that I would rather the expert have too much information than not enough, because a good expert like you, like Dr. Maddux, will know how to separate the wheat from the chaff. And also, for the benefit of any criminal defense lawyers in the cyber audience, I want to emphasize to you how important it is that you not only share discovery with the forensic mental health expert, but you share all of the discovery, the good facts as well as the bad facts, because experienced mental health experts like Dr. Atkins, like Dr. Maddux, can help explain everything. Dr. Maddux, I want to return to you. You used a couple of terms in your chapter that deserve further explanation. First of all, the term malingering. What is malingering, and can testing, can interviewing suss out any malingering?
I'd like to back up a little bit and describe a term known as dissimulation first. And
Okay.
dissimulation really means responding to questions in a way that isn't accurate. In other words, you're depressed, but you communicate you're happy. You're anxious, but you communicate you're calm, right? Or the opposite of that. You're you're calm, but you communicate you're anxious. So that's dissimulation. Now, there's a bunch of reasons why dissimulation may occur. When dissimulation is occurring for some type of secondary gain, like to get a payday in a personal injury case, or to communicate to the court that you're not competent to stand trial, then at that point, this dissimulation is known as malingering. It's responding in an invalid way for some secondary gain. Now, the reason why this is important to break down, to back up first, is because sometimes people respond in an invalid way, but it's not for a secondary gain, and people still mistakenly call that malingering, but it's not. There are many reasons people may respond in ways that are invalid, and not all of them have some type of, agenda attached to them. And it's important to highlight that, especially for the attorneys who are here, because that's a nuance that some experts in the court fail to grasp. And it's so important to grasp it because being labeled a malingerer is something that's hard to shake once it's upon you in the criminal justice system. So that's what malingering is. And yes, there are tests that can be helpful in detecting invalid responding or dissimulation. But to assess the motive for it and whether or not it's to win at trial, which would therefore be malingering, that's something that tests don't do. That's something that we do as forensic mental health experts by looking at all the other sources of data that Elliott and I have mentioned this evening.
And I should add that although Dr. Maddux discussed briefly malingering in his chapter, we have an entire chapter in the book devoted to malingering. Back to you, Dr. Maddux, with another question. You use the term Flynn effect. What is the Flynn effect?
Sure. So the Flynn effect is this really interesting phenomenon where IQ scores have been steadily rising over the decades, especially in the 20th century. It was named after a guy, James Flynn, a researcher, who noticed that people were scoring higher and higher on IQ tests over time, even though we usually think of IQ being this kind of thing that's fixed from when you were born. So Flynn observed this. And one of the wild things about it is that it's not just a small bump. We're talking about maybe an average increase of about 3 points per decade. That's pretty significant. So people wonder, like, why is this happening? And some researchers think that, it could be linked to improvements in education, more access to information, or just the complexity of modern day life, making people more adept at responding to the types of questions that are asked on these tests. Maybe it's constantly being bombarded with information, like in spaces like this and on podcasts and so forth. Perhaps it's all sharpening our skills and making us better at IQ tests somehow. But while IQ scores are rising, it doesn't necessarily mean, unfortunately, that we're all getting smarter. It could just mean that our environment is shaping us in ways to help us perform better on these instruments. The implications of this rise are significant. I mean, when you consider whether or not someone's going to get Social Security disability benefits based on an IQ score, or maybe even the death penalty, that's the implications of the Flynn effect and what that means for someone's life are noteworthy. So every time tests are re-standardized, like after an edition gets kind of old, you should know that it's taking into account for this Flynn effect phenomenon. So if tests weren't updated every few years and renormed and re-standardized on those comparison groups that I mentioned before, we'd be concerned if any of these tests are valid that are being used to assess someone who's facing, some type of capital sentencing case.
And Dr. Maddux, you've mentioned the death penalty a couple of times. Why is IQ important in the context of the death penalty?
So it's important because it's not constitutional to execute someone who has an intellectual disability. And so the importance of an IQ test is extremely important to assessing if someone has such disabilities. And obviously the scores are very, very meaningful in that context, very, very important. In fact, it's called an in Atkins' hearing. I don't think Elliott had anything to do with it.
All right, speaking of Dr. Atkins, I want to go back to you with another question. Over the years of your practice, you have observed some very creative and strategic uses of the mental health expert. Could you share with us some of those creative and strategic uses?
Well, one of them might not be considered so creative, but it's pretty fundamental to what I do. And that is to make sure that the attorney-client relationship is an effective one. Sometimes the mental health problems of the defendant create communication problems or create image problems or create a reaction in the attorney that makes it more difficult for the two of them to work together. So one of the things that a forensic mental health practitioner can help the attorney do is understand where these resistances or where these personality issues or where these obstructionistic or difficult attitudes on the part of his client are coming from. There are certain mental health diagnoses that would be predictive of these kinds of communication problems. Certainly intellectual deficiencies, people on the autism spectrum, people with borderline personality control disorder, people with paranoia, that their reaction to the defense attorney may appear to the defense attorney at face value to be that the person's being difficult or obnoxious or obstructionistic. But in fact, it's the way in which that mental health problem allows that defendant to view the lawyer and the way in which he knows how to communicate to the best of his ability, which might not be self-serving. It might be self-defeating. So that's one of the ways. I don't know how creative that is, but that's a typical role that a therapist can play. I have been involved in many cases where the client has made decisions that are counter to what the defense attorney believes are in their best interest. For example, turning down a plea offer or refusing to use an insanity defense. And the attorneys understand that by this person going to trial, the likelihood of their losing and the consequences of their losing are going to be so draconian that there must be something wrong with the defendant for them to not agree with the criminal defense attorney's idea of what would be the best direction in which to go. And a typical example is people have turned down plea offers where it was life instead of capital punishment, or life instead of a trial that would likely lead to capital punishment. And the criminal defense attorney butts heads with his client. He doesn't want his client to be subjected to the death penalty. And I would be brought in to help not only explain the client's resistance or the client's entrenchment in their position, but also in the process of doing that, perhaps to help the client to understand more clearly what the pros and cons are of sticking to his particular position. That happens not just in death penalty cases. It happens in cases where people are going to trial, where they're clearly going to be convicted of something because of the evidence. And they have a belief in their mind that if they talk to the jury, if they have their day in court, they'll be able to convince the trier of fact that they didn't do it. And sometimes that could be extremely self-defeating.
Dr. Atkins, do you ever meet with the prosecutor along with the defense attorney?
I do. More often than not, my communications with the prosecutor are conveyed through the defense attorney. But there have been times, I would say roughly 10, 15, maybe 20% of the time, where I'll meet physically with the prosecutor and the attorney, always in the presence of the attorney, never alone, or a Zoom or a telephone conference with the prosecutor, to try to give the prosecutor some insight into what it is I'm learning about the defendant that might help shape their attitude or their feelings about the defendant, including helping to shape a plea agreement or a plea offer, that rather than just waiting for my report to be written or my testimony to be heard in court, but my insights or my findings at the point in the plea negotiation process might need to be heard before the final plea offer is rendered.
Now, Dr. Atkins, a few times you have alluded to the writing of a report. Are there ever instances when you, as the forensic mental health expert, don't write a report?
Yeah, there are.
Could you describe for us those instances?
A criminal defense attorney needs to understand when they engage a forensic mental health practitioner that the findings of that evaluation might not serve the interests of the particular defense that the attorney has in mind. I cannot imagine any mental health practitioner agreeing to engage in helping in assisting an attorney. I cannot imagine them not making it clear, or that it's not understood, that what they're going to find out might not be what the attorney wants to hear. And clearly the attorney is in the position, if they don't like what they're hearing, to not want that person to write a report or not want that person to testify. It doesn't happen as often as I thought it would. I would think that there would be a lot of times where I would come up with, and there are many times where I've come up with answers or information that makes the defense attorney very uncomfortable. But more often than not, there is a way that the information I learn about the client could still be helpful to the defense attorney, even though it isn't what they had in mind.
Interesting. Interesting. Now, you, I believe, are talking about the forensic mental health expert in the context of privately retained experts. What if the expert is court appointed?
It's not that different.
Okay, tell us
It's not
why.
that different. It's not that different. As Jemour said, we are there in service to the court, and not in service to the criminal defense attorney. So whether it's privately retained counsel or whether it's a part of a public defender's office, it makes no difference. Our goal is to learn as much about the client as we possibly can and to convey those findings to the attorney, whether they're privately retained or not.
All right, thank you. Dr. Maddux, you of course are a forensic psychologist. Can forensic psychiatrists perform testing?
It depends on what you're calling testing. So tests broadly defined, yeah, there are some instruments that they have the training and expertise to administer and interpret. And yet many of you who have never attended graduate school that might be here with us today as well can also get those instruments and administer them and interpret them. And it wouldn't be wrong to call those psychological tests, maybe. So it kind of depends. But the tests that I often administer when the referral question is concerning the things that we've written about in this terrific book, you know, those are tests that aren't available to the average person through a Google search, where they can, you know, find the questions and go out, buy it, and administer it. And those are the tests that wouldn't be available to many psychiatrists who did not receive the training in psychometric science during their medical studies. Maybe I should back up and clarify, because a lot of people.
Yeah, and what are psychometric studies?
So psychometrics refer to the statistical analyses done to make sure a test is up to snuff and is performing well. Remember I broke down before the whole comparison group thing and the author will run some numbers? When I meant run numbers, I meant do the psychometric science thing. It's complicated, but I'm trying to keep it simple. What I also want to back up and say is that psychiatrists and psychologists are different. For those who may not know, psychiatrists go to medical school the same way your heart surgeon may go to medical school. But instead of doing some type of residency in, cardiac, whatever, they do their residency in mental health work, but their base training is in medicine. They went to medical school. Psychologists, we go to graduate school. We get a PhD or a doctor of psychology, a PsyD. So we're learning about psychological science, not as much medical science. We're learning about how to do research and stats and test construction and design and test interpretation. That's not something that's a part of the medical school curriculum, as far as I understand. So the test that I am authorized to use wouldn't be appropriate for a psychiatrist to use because a psychiatrist wouldn't have the training to understand how that test was constructed and what sense to make of the thing. And that could be harmful to the court and to a litigant if that psychiatrist were to endeavor to do such a thing.
I want to talk about the actual testing environment.
Yeah.
As I understand, experts like you are often specially authorized to administer a particular test. Given that, can a third party, like a parent or a guardian or even a criminal defense lawyer, be in the room while you are administering those particular tests?
Short answer is yes. The longer answer is that it is a hot button issue right now in the forensic mental health community.
Okay.
There are amicus briefs coming out on this, and there's a lot of drama about this particular
Tell
issue.
us about the drama.
All right, I'll get into it a little bit. But so many of us in the forensic mental health community are in the business of administering neuropsychological tests. We're involved in personal injury claims where we're assessing for harm due to a TBI. Someone gets hit by, some type of New York Transit bus, and now they're suing the city for their TBI. And so they go before a neuropsychologist to quantify those damages, right? The thing is that, if you have plaintiff's counsel in the room, there to get an understanding of what these tests contain and the questions that are asked, especially the instruments that detect invalid responding and dissimulation. Well, it doesn't take too much imagination to see why that might be a bad idea to be in the hands of plaintiff's bar, or even defense bar for that matter. And so many psychologists feel to protect what we do and our interests, we need to protect these tests, because if we don't, they'll become meaningless. And that's the position of many in the neuropsychological community. Now, the forensic mental health community, just my guesstimation, is somewhat split, with many believing that, listen, if you want to call yourself forensic, you're signing up to play in the law's sandbox, not your sandbox. And when you're in the sandbox of Elizabeth Kelley and her colleagues, you have to play by the rules of that sandbox. And those rules involve due process and other constitutional protections that require one to disclose the basis for your opinion, regardless. And the neuropsychologists say, well, we're not signing up for that. And so there's a thing. There's a thing within the profession, and there's a thing even between some forensic psychologists about that. But going back to my original answer, in short, the answer is yes. It's protected by the law in some jurisdictions that counsel can be in the room. Now, whether or not I want to accept a case under those conditions, I can always say no, but it is allowed.
And what if opposing counsel wants your underlying notes or the raw data from the tests? Are you in a position to share that?
In a position to share it. Back in the day, one would have a leg to stand on in that fight to protect it. But nowadays, if it doesn't include test materials, meaning the blocks that I'm using to administer the exam or the protocols that have the exam question written on it, if it doesn't involve those materials and it's just my writing or my examinee's writing, which we call test data, we don't have too much in terms of regulation to stand on to refuse to provide that. We're expected to turn it over.
All right. Now, Dr. Maddux, both you as well as Dr. Atkins practice across the country, but surely you are not licensed to practice in all 50 states plus all federal jurisdictions. How do you say go to Arkansas or go to Idaho or go to Oregon where you are not licensed?
There used to be this nifty table put out by the American Psychological Association that broke down the requirements to get like a temporary permit, if available, in a particular jurisdiction, or to find out, you know, if a particular jurisdiction allows for, let's say, 30 days of practice per year. And so there was that table there. In some jurisdictions, you just can't do anything unless you're licensed there. And that was annoying to have to go to that table because it quickly became outdated and things changed, right? But thank goodness a couple of years back, something came out called PsyPact, which allowed different states to join this compact and say, all right, if you're part of a PsyPact state and you're licensed there and you're complying with the regulations and what we expect as PsyPact, we'll allow you to do 30 days in any other PsyPact state per year. And we'll also allow you to do online testing, assessment, or therapy for an unlimited number of days per year, as long as you're seated in your home state. Unfortunately, New York is not a PsyPact state, but I sit in New Jersey today, so I'm in a PsyPact state. So I'm good to go in the PsyPact states. And that's roughly, it's above 20 states at this point that I'm allowed to zoom into to assess an examinee, or to actually go there to practice for 30 calendar days out of the year. And again, some jurisdictions, you can do that even without PsyPact, depending on how they're set up.
And I think one of the results of the pandemic is that state boundaries became much more permeable than they had in the past for a variety of different reasons. I want to ask a final question of both of you. Let's start with Dr. Atkins. Very frequently, criminal defense lawyers say to me, look, I have no medical background, I have no psychology background, no psychiatry background. How do I even begin to know if a client needs a forensic mental health expert? In other words, what are some of the telltale signs, or what are some of the red flags the criminal defense lawyer should look for? Dr. Atkins first.
I'm going to answer that in a slightly indirect way, Elizabeth.
Okay.
I think what a criminal defense attorney needs to be able to do is explain to the trier of fact, what about this person's history helps us understand why they behaved the way they did, and what about this person's mental illness or mental infirmity can be treated in a way that makes it less likely that they will engage in this kind of behavior in the future. A lot of the work that we do is considered mitigation work, where we're brought into the picture after somebody's convicted or after someone pleads guilty. The issue before the court, and usually in this case it's the judge, is not just, I need to know why this guy did it, but I need to know how to protect his community so he doesn't continue to reoffend. And it's the forensic mental health expert who is in a position to help any defense lawyer answer those questions. I don't think that the lawyer needs to see a mentally ill client in order to reach out for a mental health expert. I think they need to look at the issues that are before the court and see what kind of information would be helpful to me in my defense of this particular client.
I like the way you reframed my question. Thank you. Dr. Maddux, would you like to amplify anything that Dr. Atkins said, or do you have some red flags or telltale signs that you believe criminal defense lawyers should be alert to?
I don't have any telltale signs. I think everything needs to be looked at in context. But what I would advise is for the criminal defense attorney who's in the field to understand that they will be working with those that have mental health conditions. In the criminal law, it's inevitable. In fact, a fair amount of the work, I would imagine, is with individuals who have some type of experience in the mental health system, and if not, who have at least gone through the throes of a mental health condition. Therefore, it's incumbent upon the criminal defense attorney to spend time educating him or herself about the different issues written in this text, realizing that it's bound to come up. Attend those CLEs, and don't be shy to just jump on the phone with an expert and to ask. I mean, you're not going to get billed to ask that type of, hey, I'm thinking about retaining an expert for this type of case. Someone like me is going to say, okay, give me an understanding of what's going on. Well, I have a client, we're doing this, the client is appearing this way. And oftentimes we can provide some guidance about whether or not it might be appropriate to enlist an expert. And of course, you can also do the things that Elliott said, which I think are very wise. You can look at to see what's previously been done in such cases and get an understanding from that as well. So no telltale signs, everything in context, get the book.
I appreciate the commercial, but beyond that, what I usually tell criminal defense lawyers is, look, we're criminal defense lawyers, we're trial lawyers. We have become very keen observers of human behavior. And we have a good internal Geiger counter. And we know if something is a bit different, a bit odd, a bit beyond the norm. And I've also benefited over the years by having access to wonderful forensic mental health experts like the two of you. And particularly in my youth, I used to reach out to trusted experts and say, I have observed the following. Is this significant? And I'm largely self-taught, but having access to knowledgeable and giving experts like the two of you over the years has been absolutely crucial. I apologize to everyone in the audience because these two gentlemen had so much to say. We don't have time for question and answers. However, I can say with relative certainty that if you wanted to respond to one or both of them offline, they would probably be very happy to respond. And I should let all of you know that tomorrow we will send an email to each of you, not only thanking you for attending tonight, but we will give you the special discount code from the American Bar Association that is good for 6 weeks, I believe, and that will entitle you to a 20% discount on this book. And for any of you who watch the recording, you can also use that discount for up to 6 weeks. So once again, Dr. Atkins and Dr. Maddux, thank you for joining us this evening, and thank you for the magnificent chapters that both of you wrote in the second edition of my book, Representing People with Mental Disabilities, A Practical Guide for Criminal Defense Lawyers. Good night to you all.
Good night.